Lordship, Lordship,
has to be heard finally. We have filed
That BAD issue. In any case, my lords are not going to scrutinize thousands of appointments. It has to be left to the authorities to see whether they fulfill the stipulation laid down by the Supreme Court in the review filed by State of MP.
It's been decided, that's right. It has been decided, but they are not implementing law. They are giving a different interpretation. That is the issue.
My lord, the point is,
the state ought to have taken, the exercise ought to have been done by now in view of the decision of the Supreme. But they are not doing it.
my lord,
So
probably-
all these.
What page is the order of the Supreme Court? What page is the order of the Supreme Court?
Yes, madam. The order of the Supreme Court, Lord, is A16 at page 167, Lord. First is Lord, 812 at 59. That's clarificatory order of the Supreme, A13 at 105, that is it. Not I am referring to 595, W 595 of 2023, Lord. I am referring to that.
Devesh,
8th April order, my lord. 8th April.
Yes. The state of Madhya Pradesh files an application for clarification. They sought a clarification, they are not implementing it.
clarification has been done or not done?
Clarification has been done twice. Not first is not 105,813.
So this judgment holds the field.
Their judgment holds the.
My lord, the judgment holds the field. The judgment was clarified by order dated 8/4/2024.
Mr. Gildial,
Ji.
judgment as clarified by the subsequent order holds the field.
Yes.
That's the case of both parties.
Yes.
So we'll dispose of all these petitions in light of that judgment and they'll implement it.
But
No,
they are giving a
correct.
different interpretation.
Correct, my lord.
They are not
That is,
implementing.
Mr. Agarwal, that is not for us to clarify.
Not my submission,
That
the
is what
state
the-
has come out
if-
with a different explanation.
If they are interpreting the Supreme Court judgment incorrectly, they'll face the consequences before Supreme Court. If their interpretation is correct, then Supreme Court will uphold
Lord,
it.
what the state says, they are not required to undertake any exercise in view of the clarification.
Let us look at
That's
what
they
is,
say.
let's look at what is the direction of the Supreme
Lord,
Court.
yes.
If all of you say the judgment of the Supreme Court
Yes.
holds the field, there is no challenge to it.
Yes.
So we'll say,
We'll read plot.
come to the operative part of the judgment of the
Yes.
Supreme Court.
Plot 5 law. Yes.
My lord,
Devesh. Still the judgment.
Page 7 of the review order, my lord. Page 7 of the 8th April order.
Lord,
Second para. As it appears that a large number of candidates with B.Ed candidates had already been appointed on the basis of eligibility criteria specified by educational authorities, we do not think it to be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 23 shall have prospective operation. But the prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or condition imposed by any court of law to the effect that their appointment would be subject to final outcome of the case which might have been instituted by them.
That is
the crux. So if you are a candidate, you are disqualified, you filed a petition.
Where are you reading? Where are you?
I am reading at page 7 of the review order, madam.
Where is that? What page is the review order?
8/4.
Internal 7 page of the 8/4 order, madam.
8/4.
Page 7 of the?
Internal page 7 of the 8th April review order of the Supreme Court, madam.
Where is the review order?
There's a different case opened up, my lord. I'm not having the page
Lord,
number.
the Lordship would see 559 of 2023, Lord, WP.
We have 59.
8/4.
उसका इंटरनल 7 पे है सर. Internal page 7, last para.
Yes.
Lordship could date it, as it appears, last para, that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it to be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 23 shall have prospective operation. But prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or condition imposed by any court of law to the effect that their appointment will be subject to final outcome of the case which might have been instituted by them, and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement where B.Ed was stipulated to be a valid qualification. Services of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed prior to the date of our judgment delivered on 11th August 23. Mere selection of such candidates or their participation in the process will not entitle them. So, beloved, Supreme Court has clarified that if you have instituted a case, you have taken an interim order subject to outcome, you will not be protected because you are facing some disqualification.
Every one of them is facing a
No,
disqualification.
no.
No, certainly not. But
Thereafter,
yes,
but the Supreme Court, my lords, Supreme Court has clarified, my lord, that order.
All appointments.
By order. No, no.
All appointments. All have to go.
My lord, there, no, not at all. Not at all.
In fact, based upon this clarification, this honorable court
Yes.
earlier on 3/5/2024
Now kindly
has
see.
already disposed of these matters.
Correct, my lord.
Thereafter, again they went
My
to
lord,
the Supreme
please see
Court.
the next order.
My lord, may have a look to the order
Lord,
dated
if your lordship will hear us in
3/5/2024,
Senator, my lord,
passed
we-
in
Lord,
this bunch of matters
Lord,
itself.
if we heard एक साथ सूत्र
This
हम लोग
clarification was
एक-
considered in
Sir,
detail.
वो
One second.
in Senator we should be heard. Lord, chronologically we would put the facts.
3-5 का ऑर्डर देखे ना सर, 3-5 का ऑर्डर देखे सर.
Decide हो चुका है.
in March में the petition was
One second.
If your lordship
Agarwal.
gives us a chronological sequence, Lord.
Mr. Agarwal,
Yes,
come
yes.
to the review order of the Supreme Court.
Yes,
It says, as it appears, a large number of candidates with B.Ed have already been appointed.
yes, Lord.
Now, how many of the petitioners here have been appointed?
Petitioners are DA students.
None of them have been appointed.
Well, we have not been appointed.
All right.
Lord, the question was, Lord,
So,
they appointments, Lord, we challenge the B.Ed qualification.
Case instituted by them. नहीं, instituted also. B.Ed वाले करेंगे भाई इसको.
नामों का आपके ऑर्डर के
नामों साहब ने कर दिया, उसके बाद ये फिर क्या है?
clarification गए वो भी dismiss हो गए.
They went perfect. We have filed that order.
what remained.
आपको ऑर्डर किया था इसमें. Or may I just submit in 2 lines, my lord?
one second, let us see what
Yes.
is the direction. You see, there is a dispute between B.Ed,
B.Ed and DLED.
DLED,
B.Ed.
DLED, ma'am.
DL.
Diploma in elementary education.
So, Supreme Court says B.Ed is not a,
Eligible.
It's
Not
not a-
qualification.
Yes.
only DL.Ed is the qualification.
Yes.
But Supreme Court also notices that some have already been appointed.
Appointed.
Yes,
To them, Supreme Court have given
but
some,
there's an exception.
to some of them, Supreme Court has given protection.
To all of them, my lord, who were appointed prior to 11/8.
We don't know.
It's not like that.
One second. Prior or post is again to some,
Another extent.
so to some B.Ed protection has been granted. Now we have to see who are those B.Ed to whom
Yes.
protection has been granted.
Yes.
Let's
Exactly.
look at the order.
Yes.
Now, my lords, may I please.
Last
see?
3 lines, Lord. But
First, don't come to last 3 lines. We'll have to start from the,
Yes.
As it appears.
as it appears.
as it appears, well, I read that out, Lord. As it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it to be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 23 shall have prospective operation. But prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or condition imposed by court of law. That is one. To the effect that their appointment would be subject to final outcome of the case which might have been instituted by them. Milord, I am pausing here for a moment. This is the first condition.
So all those who had got interim orders from court,
To appear in the examination?
not protected.
Yes.
Not protected.
Yes. Then read
By
further.
them, and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement where B.Ed was specified, stipulated to be a valid qualification. Service of only such candidates shall not be disturbed because of this judgment. We make it clear that this benefit is only for the candidates who were appointed prior to the date of our judgment delivered on 11th August 23. Mere selection of such candidates or participation will not entitle them for benefit under the order. So two broad categories. 11th August prior to that protected, but even out of those who had instituted a case and appeared in pursuance of interim orders of some court which made their selection subject to that outcome. So one thing has to be seen. Did you initiate any case pursuant to which interim order you appeared in the B.Ed examination?
What about those who did not institute a case?
My lord, that has been clarified.
Clarified.
Our division bench. My lord, please see. Our division bench.
Let my friend show me.
My
That
lord,
means somebody who comes to court gets an interim protection, doesn't get protected. Somebody who does nothing gets protected. Everybody goes. Everybody goes.
my lords, may just kindly have a look on.
Can it be that someone who's approached a court of law, got an interim order, is worse off, is better off than someone who's, is worse off than someone who's sitting at home?
Sure. My lords,
The full of factors.
please.
Only those to whom there was no challenge by the state and unconditional issue
No.
said, appointed, that's the end of it. You
My lords, may please see.
One second.
My lords,
You
may.
see, there could be a situation where there is no qualification in the advertisement. B.Ed is the qualification, somebody participates, gets appointed based on B.Ed degree and is appointed. That is one category. In other cases, there is a qualification in the advertisement that you are not eligible. But they come to court says you are permitted to participate. They are not protected.
My lord,
But
here-
those-
In your advertisements,
B.Ed was the qualification.
Qualification.
was there a qualification?
B.Ed.
Was the advertisement unqualified
No.
for B.Ed?
It
Or
was.
was there a stipulation or a rider in the
No,
advertisement?
there was no rider. The qualification was B.Ed or D.Ed.
Was the advertisement subject to certain things?
No, it was not.
Was the advertisement?
Now, my lords,
Then you are protected. What is the quarrel?
my lords, my lord, but grant me a minute's time. After, my lord, Supreme Court clarified the order by this review order, the writ petitions filed before this honorable court were disposed of by the division bench. Now, my lords, may kindly have a look on the order passed by the division bench. Then I will take to your lordship to that.
What
My lord,
page is
that is, my lord, order dated 3/5/2020. Yes, that was again challenged before the Supreme Court and Supreme Court dismissed that challenge. My lords, may first kindly see 3/5.
What
3/5.
shows the order 18?
My lord, this is 3/5.
3/5.
was passed in these cases.
A15. 3/5/24.
3/5/24.
4. My lords, may kindly come to internal page 49. Internal page 49, my lords.
49 of that order.
My lords. Clause, my lord,
Yes.
12, my lords. 12 may kindly see. It reads, my lord, the conditions to be specified by B.Ed appointees are as follows. Benefit of prospective operation of judgment dated 11/8/2023 of the Apex Court shall not be available to such B.Ed appointees who had approached the court and had made their selection appointment subject to final outcome of the case instituted by them. Pertinently, since none of B.Ed appointees are before this court, the said condition is inapplicable. None of the B.Ed candidates had approached this honorable court. They were made, they had intervened in the petitions filed by the DL candidates, but none of them was a petitioner.
So they had no interim protection.
Yes.
No.
No.
They did not participate subject to some order.
No, they did not participate. Now, my lords, just a minute. Just a minute. Now, my lords, may kindly see further. B.Ed appointees should be in regular appointment based on selection pursuant to advertisement prescribing B.Ed as an essential qualification pertinently in the state of Madhya Pradesh. all the B.Ed appointees have been subjected to selection and appointment on the basis of B.Ed qualifications prescribed in recruitment rules 2018 Supra and the advertisement. So my lord, it answers the query which your lordship had raised, whether it was conditional or not. It was
No.
unconditional.
No, that is not the query. There is an advertisement published.
Yes.
If it's an unqualified advertisement, no difficulty, you are
Yes.
appointed, you are protected, provided it's prior to a cutoff date. If you were ineligible as per the advertisement, or
Then
the
you-
advertisement, that's why I began with if, or the advertisement is subject to certain things, you go to court, get an order, you are not protected. Was the advertisement pursuant to which you all participated an unqualified advertisement, or was there any qualification? We are not of court. Any qualification of
It
any
was
nature?
not. It was unqualified.
Show us the advertisement.
My lord, that advertisement. नहीं, वो बाहर नहीं हुआ। My lord, what has happened?
वो दिखा लो, निकल चेक कर।
ओ पहला वाला
इसमें बताइए।
18 बार अभी आ रहे हैं ना उस पर डीबी के बाद आ रहे हैं।
My lord, से उसमें
B1
page number. become 250. Page.
My lord, before going into that, I have got a humble submission.
137.
तो कैसे हुआ?
My lord,
1 second, 1 second.
सो हो ही नहीं सकते हैं, बाद में चाहेंगे वो तो बाद में चाहेंगे, बाद में चलेंगे तो
my lord, I have got.
उन्होंने बाद में नाम साहब ऑर्डर को अफर्म कर दिया, दैट इज द एंड ऑफ द मैटर, दैट इज द एंड ऑफ द मैटर।
Please, yes, specifically.
Malord, just submit one, just eight lines. High Court's order, Malord, division bench said that none of the B.Ed candidates were before this court, meaning thereby none of them had instituted any proceeding. This order was assayed before the Supreme Court again. And Malord, it was said that it should not be said that only instituted by them. If they are party in any proceeding,
What Supreme Court said was High Court should not have given any clarification.
no, High Court,
Please
Malord,
prove that.
Malord.
Supreme Court says, though High Court has noticed our order, so High Court had to only say, in view of Supreme Court judgment, all petitions disposed of.
and Supreme Court dismissed their petition.
They have given a detailed interpretation of the Supreme Court judgment, further issued clarification. Supreme Court says no. Please read the penultimate paragraph of the Supreme Court clarification.
This is order dated 29/7/2024.
In Devesh Sharma.
29/7.
Yes.
29/7. 18 minutes. Yes.
My lord,
Yes, yes, Manoj, may please, yes.
permit me to make one point. Probably all this exercise may not be needed, but there is one important point. Lord, there is no petition pending before my lord. Petition has been disposed of on 3rd of May, 2024.
Lord, Mr. Rupra,
That is
probably
the
I would
end of the
second that,
matter.
my lord.
Now, that is the end of the matter. Now the petition is dismissed. Now, Lord, they went to the Supreme Court. Supreme Court has not remanded it. With utmost respect, my humble submission is that the petition stands dismissed. Supreme Court has not remanded the matter at all. So, Lord, this High Court is not seized of the matter. So it appears that there is some error by the registry of the High Court that the writ petition has been taken to have been remanded, and we are hearing it. Lord, I have
Malaj, I'm sorry, I have an objection to that. If my lord would just give me 2 minutes because I was assisting the Honorable Supreme Court in this very matter. In this very matter.
my
So
lord,
1 second, please.
मेरे को
Because I can- 1 second, please.
Mr. Kalra,
I may be either.
please wait for your turn.
Wait, my lord, what Mr.
Wait,
Rupra is
Mr. Kalra, please wait for it. Let him make his submission, then you can
Very
object.
Very well, my lord.
I've got only two humble submissions, Lord. Firstly, the petition stands dismissed, Lord, and matter has not been remanded by the apex court on 18/12/2024. This is my first submission. Second submission is, my Lord, that this is not a PIL. Only two petitioners are challenging the appointment order of more than 11,000. Lord, in service matters, we don't have PIL, Lord. This need not be told to my learned friends, Lord. And my Lord, I have filed one IA number 2962, precisely and very, very concisely. I put in that point. Now, my Lord, first I will invite my Lord's kind attention to this IA number 2962. Only 2 paras, 3 paras I'll read, my Lord. That will put. We are not seized of the matter.
3-5 quarter for the lord. 3-5 quarter. Nothing has been destroyed.
We are here on
Subsequent order. Application will be only in a
And petition जो pending नहीं हो.
तो नहीं हुआ order.
We are not here in PIL. We are not here in.
And petitions are pending. Petition twice.
I have minutely examined.
But from the issues and the basis of that judgment, the ratios it would pass subsequent order on all the pending applications.
The particular. यार ये जो गज ने फाइल की ने उसका रिकॉर्ड फाइल किया है उस प्रेयर वाज पिटीशन इंस्टीट्यूटेड बाय टीएनएड में भी अगर ऑर्डर हुआ है कब भी उसको पढ़ा यार
There is
दैट हैज बीन हां देखा ना
Which were the petitions which were pending when the Supreme Court order was passed?
Yes, that is the.
It says pass orders on all pending applications and petitions. There's no petition pending.
Lord, the Lordship would see his clarificatory order.
registry has restored.
18/12/2024.
Yeah, last paragraph.
They went to the Supreme Court block against an order dated not 359 and passed in WP 595, which is before a Lordship.
All these batch of matters, it's a detailed order in all batch of matters.
Yes, Lord, but that. The 595 was the main matter before the Supreme Court
Yeah.
also brought. So this petition before a Lordship 595.
So the petition is not pending.
Not, it says, in view of the above, it
Yeah.
dispose of the special petition with a request to the Madhya Pradesh High Court to do the needful.
Two,
To do the needful.
In the pending.
needful as in the previous paragraph.
Yes, in Devesh Sharma and subsequent clarification, we have absolutely no doubt in our mind that we had made it very clear. Both for the diploma candidates as well as for the BA candidates, where they stand although the division bench of the Madhya Pradesh High Court has taken note of our judgment, but we would appreciate that actually on the basis of that judgment, it would pass subsequent orders
On all
the
pending applications and petitions.
on all the points which has not been done in the said judgment. In view of the above, we dispose of these special petitions with a request to the High Court, to the Madhya Pradesh High Court.
So when you all are saying that those judgments squarely apply, that's the end of it. There's nothing pending before us.
If you're not sure with this, the last two lines below. In
Needful.
view of the above, we dispose of the special petition with a request to the Madhya Pradesh High Court to do the virtually it's a remand.
That is it. No, there is no remand.
Virtually,
No remand. Mr. Agarwal, what our understanding of the Supreme Court December order is that we had clarified our stand in the first petition, first order.
Yes.
There was no requirement for the High Court to have passed a detailed order because what we had said was clear. Nonetheless, High Court has referred to it. High Court also says disposed of in terms of the Supreme Court order. So they're saying if there is still anything pending, any application, anything pending, dispose it of in terms of our judgment. That's all. So
Registry
we
has
say all these petitions are disposed of in terms of the judgment of the Supreme Court dated so and so period.
and registry has restored that case, my lord, 595.
Nothing restored.
And please see the status. It shows restoration by case number 13768 of. Please see the status of this case, my lord.
Maybe somebody moved an application or something.
No,
We
there's
are
no
not
application, my lord. We verified.
We are not going to clarify anything. We can't clarify.
What the High Court would be required to do in view of the judgment of this.
High Court is to do, High Court, if there was something pending, High Court have
Dispose
adjudicated
of
it.
these special petition with a request to the High Court to do the.
So we'll do the needful. We'll say all petitions disposed of in terms of the judgment of the Supreme Court. All pending, we don't need to clarify, we can't clarify.
That would have been okay. The problem is now in the garb of that
If they are-
clarification subsequently.
Mr.
given,
Sharma.
but the fact that all appointments, my lord,
Mr.
were
Sharma.
subject to outcome
No,
of
Mr. Sharma. If they are incorrectly implementing the Supreme Court judgment, you have your remedy. We can't.
Well, that
Please
will
tell us,
throw us into an endless.
Mr. Sharma, Mr. Sharma, either you are asking us to initiate contempt because of their not following the Supreme Court judgment, which we will not have the power to. It's an order of the Supreme Court. They have to apply it. And your remedy will lie before the Supreme Court. Or we will now interpret and say, please implement the judgment of the Supreme Court. Supreme Court has clarified the position. Both sides are saying that is the position in law. But ultimately, your argument is that they are not correctly interpreting it or
To do, my lord, more than whatever 10, 20,000 people they have brought in at the cost of the diploma, what the law has been held up. They are trying to protect them under the cheap that level.
Mr. Sharma.
Every single appointment.
Mr. Sharma, if there is a breach of the Supreme Court judgment, what is the remedy? Not another reiteration by the High Court. We can't hear arguments and reiterate the judgment which Supreme Court has given. All we have to say, Supreme Court has decided it, parties will implement.
On the
That's
basis
it.
of this judgment, Lord, in Chhattisgarh, all the appointments have been cancelled, other states also.
If it is cancelled, it's cancelled. If it
Not-
liable to.
But they are not implementing the order here, Lord. They are
then-
interpreting it
then-
otherwise.
Mr. Agarwal, what is the remedy? Who will interpret it correctly and who will say
Lord,
they've wrongly
Lord,
interpreted?
in view of the direction of the Supreme Court, Lord, if it-
Supreme Court has not empowered us.
Lord,
Supreme Court has not empowered us to initiate contempt because of violation of Supreme Court order. Supreme Court has said any further petition pending before you, dispose it of in terms of our order.
Lord,
Don't
Lord,
look.
before saying, Lord, at the cost
Lord,
of-
can I just take 60 seconds if my lord would now permit, just to cut this controversy short, my lord, just 60 seconds by clock if I can take, if my lord would permit.
But the direction is.
My lord, kindly come to first page of the Supreme Court order, my lord, kindly come to page.
And petition.
My lord, just give me 60 seconds, I will cut the controversy short, I'll make an attempt, my lord.
Mr. Kalra, we'll hear you once again, Mr. Kalra. So that is how it has to go. We'll simply have to say Supreme Court has already decided this list. These petitions already stand disposed of. There is nothing pending.
Lord, if a lordship would say again, when I read it again at the cost of the petition, my lord. In view of the above, we dispose of these especially petitions with a request to the High Court to do the
Needful meaning what?
interlocutory applications. If any are disposed, the pending interlocutory application before the Supreme Court were disposed of. Lord.
This is Supreme Court.
Yes,
The previous line,
previous line. So, Lord,
Well, then, the High Court's judgment, well, that was passed, it was well within the knowledge that what they have not done their judgment they should do. That's why it's a remand.
Sorry?
Let me kindly see, we'll read it. Because the
does
disposal.
the High Court say petitions are restored?
No.
Or remitted? Supreme Court doesn't say all these petitions which were disposed of by that order are restored.
Kindly read that part once again.
Read it.
In Devesh Sharma Supra, in the subsequent clarification, we have absolutely no doubt in our mind that we have made the position very clear, both for the diploma candidates as well as for the B.Ed candidates where they stand. Although the division bench of the Madhya Pradesh High Court has taken note of our judgment, but we would appreciate that if on the basis of that judgment, it would pass subsequent orders on all pending applications and petitions on all points, which has not been done in the said judgment.
Which judgment?
That judgment of the division bench was under challenge.
So we will ignore the judgment of the division bench. We will say Supreme Court judgment prevails. All petitions disposed of in terms of pending petitions disposed of in terms of Supreme Court judgment. That's all.
That's why it says.
We don't need to clarify or now decide any list. And especially when both parties are saying that judgment applies. You see, ultimately your grievance, Mr. Sharma, is not with regard to any finding of fact or any finding in law. Your grievance only is, look, Supreme Court has decided their rights. They are not, state government is ignoring it. Remedy is where? Not before us. Go to the Supreme Court, raise a grievance, there is contempt or breach of your order, Supreme Court will pass appropriate orders. Then they will justify their stand. That this is what we understand. We can't interpret the Supreme Court judgment and say, no, Supreme Court meant this. That's not what we can do. We have to simply sit and say, this is what the Supreme Court has said. All pending petitions are disposed of in terms of that order. Now, if you feel that they're wrongly interpreting it, wrongly implementing it, Supreme Court can clarify. We can't.
My humble submission is that it's these matters are set out ballot and it's at Senator ballot we are able to point out all the decisions.
So, which petition out of these all is not covered by the earlier judgment of this division bench? Division bench says all petitions are disposed of. Which one is not part of that list?
WP 3416 2025.
That will dispose of in terms of the Supreme Court order in one line.
I have challenged the rule.
You may challenge anything. We will dispose it of in terms of the Supreme Court order. Period. We are not going to look into rules. The Supreme Court has settled it. Now we will pass a judgment differing from the Supreme Court.
The preemptory order से divorce it's first. Meanwhile, other cases were decided. भी तो नहीं पड़ गया ये कैसे रेस्टोर हो ये आपकी भी पिटीशन डिस्पोजल हो चुकी है 1376 वाटर मैनेज wait it's done that has been resolved by this case
विड्रॉ कर ली
3416
वो विड्रॉ कर ली
रेस्टोर हो गई
3416 to 925 ये challenge the rules and the law so और बता के खत्म चैलेंज करना है अब बताओ ये भी सुप्रीम कोर्ट के ऑर्डर से संबंधित
Yes, Mr. Kalra.
I'm grateful, my lord. My lord, kindly, I'll just take 2 minutes maximum, my lord. Kindly have the first page of the Supreme Court order, my lord. The first page where the appearances are recorded. I'm saying this with responsibility because I assisted the Honorable Court. This second name in page 1 is mine, my lord.
Which order are you referring to?
The order is dated, my lord, 18th December 2024. On the top in the order, my lord, it challenges the final judgment of this Honorable Court, dated 3rd May 24. My lords have the order of 18th December.
Yes.
On the top, my lord would see arising out of the impugned final judgment and order dated 3rd May 24. And then my lord would see the appearances. The second name in the second appearance is mine, my lord. So I had the occasion of assisting the Honorable Supreme Court in this very matter. So I'm saying it with responsibility, my lord. Then my lords may kindly come to page 3, my lord.
Yes.
Page 3, my lord, there is a clarificatory order of the Honorable Supreme Court which has been reproduced now in the very same order. In this, my lord would just see it carries on to page 4, my lord. It starts from moreover the candidates. The controversy is really this, my lord. Kindly see page 4 now. And
Yes.
1812 order, my lord.
Yes.
Yes, my lord would just have 2 words with me. Just last part of page 3. I'm reading the last part of page 3, my lord, because the clarification is recorded. Kindly have the mid page, my lord, at page 3. The sentence starts, but prospective operation of this judgment at page 3, midline. But prospective operation of this judgment. My lords have that?
Yes.
But prospective operation of this judgment shall be only for those candidates who were appointed without any qualification or conditions imposed by any court of law to the effect that their appointment would be subject to final outcome of the case which might had been instituted by them. And such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement where be it was stipulated. So this is a relief, my lord, that is being reproduced in the present order, which was given in a clarification to the original judgment. The clarification is dated 8/4, my lord, which is reproduced.
What is your submission, Mr.
The submission is this, my lord, that the original judgment which was challenged before Honorable Supreme Court, this very clarification which I was just reading, held to the contrary. The original judgment of this Honorable Court said that this very clarification which I am reading would not apply to the present case because the present writ petitions, the batch which my lords are now hearing, were not filed by B.Ed candidates. I repeat myself. We were trying to seek an implementation of Honorable Supreme Court's clarification. The clarification said that only those appointments will continue which did not have a rider or an interim order. In the present batch of matter, there was always a rider and an interim order, which I can show. Still, those appointments were not removed.
Mr. Kalra, if they were appointed subject to an interim order, they have no protection.
They have no protection, exactly. But
That's
still,
all.
yes. But what happened is, the previous order, which I have assailed before the Honorable Supreme Court, does not remove those people. That is my main grievance.
Mr. Kalra, we are not supposed to remove anybody.
Malaj,
We are-
I just clarify.
You have to dispose of petitions in terms of the Supreme Court order. That's all.
Yes.
And
Yes, I will just clarify that.
in which petition are you appearing?
I am appearing, my lord. In today, the petition which is listed, this is writ petition number 2218 of 23. 2218 of 23 is the one which I am appearing in. But
One
what I
second.
am trying to say is, my lord,
One second.
Yes, yes. The fact of remand word not being mentioned is inconsequential for this reason, that the intent of the Honorable Supreme Court while passing this order, which I said I assisted with responsibility, I am saying, was to send the matter back. Because they were
Sorry,
not
Mr. Kalra, that is not 2218 stands disposed of. There is nothing pending.
No, my lord, the point, just bear with me for a minute.
Adil, can I get a bite? 2 minutes.
Yes, yes, please, please. Can I just share that chart once? It will just make it easier.
2218, who's appearing? You are appearing or he is appearing? Power is of Qazi Fakhruddin.
Yes, sir.
Kalra is appearing for whom?
Studied along with us.
So you are there
Yeah.
as a senior counsel. So you will make submissions.
No, my lord, I have been engaged to appear in this matter, but can I just cut the controversy short? Please give me 60 seconds more. Can we just have one chart?
Kalra, none of these petitions are pending. None of these petitions have been restored.
My lord, the word pending petitions need not be read as the fact that there is something pending in the High Court. I am saying it with responsibility. On that day when we were arguing before the Honorable Supreme Court, there was nothing pending in the High Court. There is nothing
That's-
pending. Zero.
There is still a petition. Mr. Thakur appears in a petition which is not part of that batch.
The
There is
point
a
is,
petition pending. There are several petitions which are not part of that batch. They are pending.
no, the point that I am trying to make is this. Kindly bear with me. It's for 60 seconds, not more than that. The Supreme Court in the present batch has actually remanded the matters back. It may not come from the wordings of the order, which I agree. My lord, it's
Kalra,
absolutely correct.
sorry. That is now how we can interpret a Supreme Court order. The Supreme
Well,
Court.
so therefore,
High Court has to dispose of all pending matters in terms of our judgment. But all these petitions are all right. Can we re-adjudicate this issue?
my lords, it has to be. Can I just show one line? Can I just show one line? It is not to be re-adjudicated. It has to
File
be.
an affidavit, Mr. Kalra, that this has to, as per the Supreme Court order, this has to be reheard and Supreme Court order has to be revisited by this court. File an affidavit.
My lord, I'll file an affidavit. Absolutely.
May I make a suggestion?
Yes.
Mr. Fakruddin, are you instructing this? That you will file an affidavit saying that we have to revisit the Supreme Court judgment?
My lord, this is not.
That's what
revisiting
Mr.
the
Kalra
Supreme
is
Court.
submitting.
No. Can I
Supreme
just
Court has
clarify?
said you have to rehear everything and decide.
Can I just
Submission. And
Can
if
I
you
just
file
frame
an
my
affidavit-
submission? Just give me 30 seconds. I reframe my submission. I am saying the earlier judgment of this court has to be revisited. The earlier judgment of this court has to be revisited. Is my submission.
Mandeep, ek minute.
36.13 to 19 are pending petitions.
Plus, may I have your lordships?
But disposed of.
May I have your lordships leave to address your lordships for 2 minutes
Yes.
plus your lordships permit. But the controversy is this, Milas. In the first round before the Supreme Court, Milas, the Supreme Court was categorical that it is only the diploma holders who are entitled to as a matter of right. What they did was only protect those B.Ed candidates who had already been appointed or were in the process of being appointed under interim orders of the court. The clarification subsequently which came to the main judgment of the Supreme Court was also categorical. It says that those people, that is B.Ed holders, had to initiate proceedings. The proceedings which arise out of the Supreme Court order, Milas, including the one which I am appearing in, writ petition number 595, which is subject matter of your lordship's disposal by the earlier division bench, which was later challenged before the Supreme Court, upon which this 18th December 24 matter arose, Milas, are proceedings initiated by diploma holders effectively effectuating the orders of the Supreme Court. So in fact, Milas, the B.Ed holders did not file any proceeding therein. Unfortunately for us, Milas, what had happened was, in our writ petition, effectively, we had all been granted relief because the state for some reason doesn't want to execute the relief in our favor. That's one thing. Your lordships also rightly pointed out that the remedy lied elsewhere. But we were already pending before this court, Milas, when the clarifications came. And the writ petition was unfortunately disposed of, saying all people are protected. It is for that reason that as third party, there were some people who approached the Supreme Court and writ petitioners themselves approached the Supreme Court, Milas, claiming just one relief, that B.Ed holders could have been protected in view of the clarificatory judgment of the Supreme Court only if they had instituted proceedings that obtained stay or their appointment had already been finalized before the Supreme Court judgment came. With due respect, Milas, I understand the word remand, the word reconsider, etc. does not find mention in the Supreme. My request to your lordships would be twofold, Milas. Either we read in a more meaningful manner the Supreme Court, because otherwise there was no reason for the Supreme Court to say that pending applications your lordships will take care.
Mr. Parmeshwar, our reading of the Supreme Court order is that Supreme Court said the High Court division bench should not have revisited or passed any order after we have clarified the position.
That's right, Milas.
What we intend to do is all pending petitions and applications disposed of in terms of the judgment of the Supreme Court. Period.
Would your lordships give me one liberty then? Would your lordships give me one liberty? I understand, because your lordships will now see the problem so far as the diploma holders are concerned, Milas. We have won all through. The Supreme Court judgment is in our favor. Even when the High Court division bench tries to interpret the Supreme Court order, the Supreme Court order tells them not to do that. But unfortunately, Milas, that one line is missing. Can I do this, Milas? If it means with the...
There was a remit. We have to still decide it in terms of the Supreme Court judgment.
All right. Understand, Milas. Understand. Would your lordship do me this, give me this liberty? Would your lordships keep this pending, Milas? I will file a review petition immediately tomorrow. Because in the review, then there will be something pending. Because otherwise, look at this, Milas. 3 rounds we have succeeded before the
Review
Supreme
petition
Court.
where?
Here, Milas.
before the Supreme Court.
Here, before your lordships. Before your
Here
lordships.
you are in Delhi.
I'm sorry.
Jabalpur.
He's in Delhi.
Sorry.
You should have said there.
I said before your lordship. When I mean, I'm.
No, you see, review of what, so when Supreme Court says High Court, actually the purport is High Court should not have re-examined of a judgment. We've already
That's right.
clarified
That's
it.
right. Because unfortunately,
Now you are wanting to move a review for us to now exactly.
No, I'm not. Would your lordship just bear with me for a minute? Look at how this has happened. This is Operation
Here,
Successful.
Mr.
Patient died so
Parmeshwar,
far as we are
Mr.
concerned.
Parmeshwar, once that judgment has merged with the order of the Supreme Court, this is not Kuni Ahmed will apply that it's an illiberal dismissal, review will lie.
Milaz,
No
there are
review
two.
will lie before us.
There are two reasons. Milaz, Kuni Ahmed says, only if one's leave is granted, Milaz, there will be merger. Only once leave is granted, there will be merger. Fortunately for me, Milaz, that window is not closed in the Supreme Court order. Would your lordships only see this? Look at the plight of the diploma holders, Milaz. They win 3 rounds. They win the Supreme Court in the first round. In the clarificatory order, they win, Milaz. Before your lordships, Milaz, unfortunately, the judgment doesn't go in our favor. In fact, it makes things worse for us. It goes in the favor of tBed. Unfortunately, Milaz, the states does.
Mr. Parmeshwar, sorry, first line says, permission to file special leave petition is granted.
Plus, that was because
no leave, Milaz. That is
Mr. Kalra, please wait.
Milaz, that was because
Special leave is granted in the second, in the recall order.
No, that is
No,
not.
Milaz, may I just explain that? Milaz, there were multiple people there. People who had filed petitions, leave was granted for people who had not been parties in the High Court. For them, leave to file special leave was granted. Not that leave was granted for 136, Milaz, with all due respect. Milaz, look at this, Milaz. 3 rounds we win. 3 rounds we win, Milaz. Unfortunately, Milaz, the state doesn't seem to be even called upon to answer why they have not implemented the Supreme Court directions. With all due respect, Milaz. If the review is filed, Milaz, then in the review, your lordships will definitely be able to do this. Kindly permit us. Otherwise, such gross injustice will happen. 3 rounds after having won 3 rounds, Milaz.
And just to add on, my lords.
Andeep, 1 minute, 1 minute.
It's a list for consideration on 9th September 2025.
Grateful.
Some of the petition is a fresh petition.
Whatever, we'll consider all of them.
Grateful.
Ultimately, Supreme Court has settled it completely.
But the Honorable High Court said that the rule is not given in the earlier round of litigation.
Even if you challenge it now, Supreme Court has settled it, we can't look into it.
That has already.
Grateful.
Grateful, my lords, deeply grateful.
My lord, item 38, my lord, your lordships transfer the 62 to 65 years issues, my lord. My lord,